Will Rudy Giuliani really flip on Donald Trump? Giuliani has reportedly met with prosecutors under conditions known as a proffer. But Giuliani's own legal exposure must be alarming to him, as well as his legal team. Rudy Giuliani has had a lot of titles before his name, but the one he wants to avoid is defendant. He is the former Associate Attorney General of the United States, the number 3 at the Justice Department, U.S. Attorney for the Southern District of New York, Mayor of New York City, and personal lawyer to Donald Trump. But now, following reports that he met with special counsel Jack Smith's team in their criminal investigation of the January 6 uprising, Giuliani finds himself the focus of speculation whether he will flip on Donald Trump. Much of that speculation is hype over the reporting by the New York Times and CNN that Giuliani met with prosecutors under conditions known as a proffer. But proffers do not always lead to a cooperation agreement. Rather, they are a method by which white-collar defense lawyers seek to probe what the prosecutor's interest is in the client and to see if they can assuage any suspicions by the prosecution that the client has committed crimes. An old adage in white-collar defense is the distinction between these categories of crimes versus violent crimes. In violent crimes, it's a whodunit. In white-collar crimes, it's often the question of whether anything was criminally done at all. From the reporting, it appears that interest and questioning of Giuliani focused on a wide variety of topics, all related to efforts to overturn the 2020 election. Prosecutors asked him about the role of John Eastman, the mastermind, who theorized how Trump could overturn the election through Vice President Mike Pence rejecting the Electoral College vote, Sidney Powell, who had made baseless claims about foreign entities' mass hacking of voting machines, and the meeting at the Willard Hotel days before the January 6 attack on the Capitol. Giuliani was at the center of all of this, so if any of those people and actions may be subject to criminal charges, then his own exposure must be alarming to him as well as to his legal team. But it is too early and we don't know enough to say whether DOJ is looking to charge him. The proffer conditions can vary from case to case and fall into 2 categories. The first type is where the client does not speak or even show up, and it is merely the defense counsel who meet with agents and prosecutors to explain what their client would say in the hope that it will lessen interest in charging the client. In such a preliminary meeting, the defense counsel will want to know if their client is a target, subject, or witness. The hope is that they are a witness. The fear is that they are a target or a subject. The anxiety is that none of those terms are binding on the government. It can all slide south for the client depending on the evidence developed in the case. The second type of proffer, and the one it sounds like Giuliani did, is where the actual client is offered up to speak to the prosecutors. But in order to give the client some type of protection, the conditions of the interview will be that nothing the client says will be directly used against them unless they lie. This is commonly called the "Queen for a Day" letter because it is usually formalized for the client's protection via a letter from the prosecutors. But being "Queen for a Day" offers limited protection since evidence developed from independent sources could still be used against the client and his statements could validate and even lead to other evidence against them. The real protection offered by this proffer condition for the client is that prosecutors know that if they use the statements to charge the Queen, then they will likely face litigation over whether the evidence used to charge was truly independent or not.